Many foreign investors believe that once they own shares in a company in Vietnam, their position is secure. On paper, ownership represents control. But in reality, ownership without proper legal protection can be misleading. Without a shareholders agreement in Vietnam, your rights as an investor may not be clearly defined or enforceable. This is where many investors begin to lose control without realizing it. A shareholders agreement in Vietnam is a private legal contract that defines the relationship between investors. Unlike the company charter in Vietnam, which governs the company's public structure, the shareholders agreement focuses on internal rights and obligations. It determines how decisions are made, how conflicts are handled, and how control is maintained over time. Some foreign investors assume that the company charter is sufficient to protect their interests. Others rely on trust between partners or informal arrangements. In some cases, investors delay drafting a shareholders agreement in Vietnam until after incorporation. These assumptions create gaps in legal protection. By the time issues arise, it may be too late to correct them. Under Vietnam company law, control is not determined solely by ownership percentage. It depends on how rights are structured. Without a shareholders agreement in Vietnam, key decisions may be made without your approval. Even majority shareholders can find themselves unable to influence important matters if voting rights and approval mechanisms are not properly defined. One of the most important features of a shareholders agreement is the concept of reserved matters. These are decisions that require approval from specific investors. They may include capital increases, changes in business direction, or appointment of management. Without clearly defined reserved matters, critical decisions can be made without your consent, reducing your control over the company. A shareholders agreement in Vietnam also defines how investors can exit the company. Provisions such as tag-along rights, drag-along rights, and share transfer restrictions ensure that investors can exit under fair conditions. Without these clauses, foreign investors may be locked into unfavorable situations or unable to realize the value of their investment. Disputes are a natural part of any business relationship. However, without a shareholders agreement in Vietnam, there may be no clear mechanism to resolve them. This can lead to prolonged conflicts that disrupt operations and damage the business. A well-drafted agreement provides structured solutions for resolving disagreements before they escalate. Another common issue is the lack of alignment between the shareholders agreement and the company charter in Vietnam. If the two documents conflict, enforcement becomes uncertain. In practice, authorities often rely on the company charter, which may limit the effectiveness of your private agreement. This highlights the importance of structuring both documents together. There have been cases where foreign investors in Vietnam lost influence over their companies because key protections were not included in a shareholders agreement. In some situations, they were unable to block decisions or exit their investment. These outcomes are not rare. They are common legal risks when proper documentation is not in place from the beginning. At LTS Law, we provide legal services for foreign investors in Vietnam by drafting and reviewing shareholders agreements that are tailored to your investment structure. We ensure that your rights are clearly defined, enforceable, and aligned with Vietnam company law. Before investing in Vietnam, visit lts.com.vn and consult with our legal team to ensure your control is protected from day one.